This is the first webinar in the Tennessee Film and Entertainment webinar series, which is hosted by the Arts and Business Council of Greater Nashville in partnership with the Tennessee Entertainment Commission. Today's webinar, Legal and Business Issues for Independent Filmmakers, is the first of 4 webinars in the series. So you'll want to follow the Arts and Business Council and the Tennessee Entertainment Commission on social media. Or sign up for our email newsletter for updates when future webinars are announced. You'll see a link to our website and to the Tennessee Entertainment Commission website in the chat. I want to share a quick video from the Tennessee Entertainment Commission. So I'm going to pull that up and play that for everyone, and then we'll jump right into the session. Yeah, so $6 billion, billion with a B, in annual economic impact from the entertainment industries in Tennessee. It's incredible. So thank you again to the Tennessee Entertainment Commission for supporting this webinar series and for all that the commission does to support Tennessee's creative class. We really appreciate the incredible work that the Tennessee Entertainment Commission does. I want to remind everyone, you probably heard this when you joined the session, but this is being recorded, and we will share a link to the session afterward in case you miss anything or you get disconnected. Also, if you are an attorney attending today for continuing legal education credit, you will want to follow the chat feature closely because we will be sharing a 6-letter code randomly throughout the next 2 hours, and you will want to collect that, all the letters of that code, and put that on the CLE form that was emailed out to you. I'll also share that CLE form in the chat in a little bit, so you'll have access to that if you don't have the email. But you'll want to record all of those and put that on the form, and that's just the proof of attendance today. You'll note that on the recording, you will not be able to see that code. It will only be available in the live session. So you cannot rewatch the video for CLE credit. You must be in attendance live to be able to get that. And with that, I'm excited to introduce today's speaker, Kirk Schroder. Kirk is a partner at Schroder Brooks Law Firm in the DC area, and he's an experienced entertainment and arts law attorney. He's been recognized in the best lawyers in America for the field of entertainment law and is currently rated AV Preeminent Lawyer by Martindale-Hubbell, its highest rating for lawyers. Kirk's national peers in the entertainment and sports law profession elected him the current chair of the American Bar Association's Entertainment and Sports Law section. His law practice draws entertainment and arts-related clients from around the world. Kirk, thank you so much for being here today and for leading the session.
Great, thank you, Jonathan, and welcome everyone, and good morning. I'm actually talking to you from a hotel room in Florida. I was trying to get the right backdrop and everything, but this is going to be the best I can do. I want to thank the Tennessee Entertainment Commission as well as the Arts Council of Greater Nashville for hosting this and giving me the opportunity to be with you today to talk about legal and business issues for for independent filmmakers. I'm going to divide this talk in 4 sections, mainly talk about the development phase in filmmaking, talk about the production phase, the distribution phase, and then what I call the just the financing or the funding. Some of these will overlap, but I'm going to break those down. And I'm just going to tell you up front that on each one of these phases, I could spend 3 hours talking about each one. And so you may feel like as I go through things that you're just getting a fire hose of information, but my goal today is to give you a sufficient overview to navigate these areas, whether you are representing clients in this area or you are a filmmaker, as well as to answer whatever questions you may have. Speaking of questions, I think I'm just going to go ahead and just take them as we roll along, especially if we're talking about particular phases. As I move on from one phase to the other, I'll ask the audience if there are any questions, and just try to knock those out as quickly as you can. Jonathan's going to help me monitor those, but I'll be looking at the chat box. So if you do have a question, pop it in the chat box, or if need be, I'll just call on you to clarify it as we move along. I put together a lot of neat materials for you, which you should have. If for some reason you don't have it, just let Jonathan know. About 12 items. I just want to go over those, just identify those really quickly. I've got production checklists. I've got a personal appearance release in there. I've got an actual production agreement if you're being hired to do a PSA, production services for any, being commissioned. So I've got 2 of those. A very important agreement, underlying rights option agreement. And then I actually have a few documents, especially on attachment agreements and things like that, that are actually negotiated. So you'll actually see my comments on those agreements, just to give you a feel of how some of those are negotiated. Life story rights, very common thing that filmmakers want to have when they want to do a story. Let's see, I'm losing my screen here. When they want to do a story on someone's life, circumstances or things like that. So I would, commend you. I'm not going to go through these documents. I just want to make you aware that they are there for your benefit. And I think there would be good reference points, especially on a lot of basic fundamentals that you might want as a filmmaker, or and likewise to see how things. Another one is people will talk about what a back end is in film and television, and I have some examples of what is called a modified adjusted gross language, MAGAR language. And then let's see, yep, it's in there. I have a summary of the new streaming services. We'll talk about that when we get into distribution. There is a main outline that I'm just going to follow, and that's also in your materials. And my computer is just slightly slow, so just be patient with me, but I'm just going to start rolling into these topics. All right, as I mentioned, today in the course of 2 hours, which are 2 days, I'm going to talk with you all about the development phase, financing phase, the distribution and exhibition phase, and the production phase of the filmmaking world. So let's start first with the development phase, and that is where you are at concept and you want to start putting and developing the project. Now, remember, you could be financing a film or trying to get financing during the development phase, or you could be working on some sort of distribution at that time. So these phases can overlap, and typically they do overlap, but I just want to break down the importance of each one and things that you need to be aware of. I will just tell you up front that mistakes made in the development phase are very costly, and sometimes can kill a project. I remember one time I was at a premiere of a client's film, and I started hearing some music in the film, and I thought, I don't remember that ever being cleared. And then later went to the client and said, hey, was that music ever cleared? Did you ever get the rights to that music? And the client thought, oh no, it's this, it's that, it's fair use, it's all over the map. And I think about $40,000 later, and that was because we couldn't get the rights to the music, and the client had to go back into post to actually take it out. Was a very brutal experience. mainly in the development phase, it's very key that you have your rights secured and that you're not infringing upon other parties' rights. Let me just say at the outset that if you have original material, it's just really important that you copyright that material. There is no such thing as the poor man's copyright, at least when people you say that phrase. I've had some people over the years tell me that they've sent a copy of the script or something to the WGA, and somehow that meant that they have certain rights. None of that is really, from a legal standpoint. At best, it might be evidentiary, but certainly nothing conclusive for you. The best presumption is when you formally register and copyright your work. What does that do? One, if you were ever in a court of law or in any type of arbitration or legal situation, you have the presumption of ownership. And that means that the burden of proving that that it's not yours falls on the other party. If you don't have that registration, then you have to prove your ownership. And sometimes that's, that may or may not be easy depending on the circumstances. The second benefit of copyright registration is that it enables you to have a host of remedies that you don't normally get without a registration. One thing that lawyers particularly like is the ability to collect attorney fees, which the whole idea of the registration is that even artists that can't afford attorneys will have some means of enforcing their rights by being able to have an attorney collect fees. You also have the ability to get injunctive relief. You can take a project down out of distribution. You can also get punitive damages when there are willful when someone is willfully taken from your work. So that's really critical, and I just want to emphasize that right at the outset. Typically, for most filmmakers in the development phase, they're not ready to shoot yet, and they are either looking for funding or they're looking to try to put things together. And that means that at some point they need to attach certain rights to the project. So the development phase is predominantly a contractual phase where you are going after to attach rights to various different things. What type of rights? It could be rights to a script. It could be underlying rights to a news story. Right now, I'm negotiating. I represent a fairly popular news reporter who did years of research on a particular subject matter. And while the producer doesn't have the rights to the subject matter, the producer wants the rights to the story and my client's research. And so we're negotiating what that might look like. Then, the most obvious would be an underlying life story rights. When you're talking about life story rights, it could be, someone's experience in a particular situation. I have a client who was a famous music producer, and dealt with such clients such as Mick Jagger, Aretha Franklin. The list just goes on and on and on. And so we're negotiating with a major broadcast network to do a miniseries on his life story. And it's basically the story of his music career. One of the key things in negotiating life stories is you want to make sure that you have the right balance in what you're negotiating. And what do I mean by balance? The scope of the life story is always critical. Very few people I know will just sign underlying life stories right agreement to just give you someone's entire life story. Does that mean the time that they got into a fight in 8th grade? Does that mean the time that they went out and did some wild and crazy things in high school, or those ventures in college? Very few people, and I find that some of my clients, filmmaker clients, get caught up on this, and I will just press them and say, look, we need to define what the scope of what you're looking for, and make sure that that story is tied up and attached with you in a contractual arrangement, versus just saying, hey, I just have your whole life story. So that is usually critical. And for those of you who have a life story, you just don't want to give out a blank check on everything in that regard. It's also important in the development phase, especially if you are a new filmmaker and you're looking to do a co-production with another producer. Typically, that co-producing partner is someone who's more experienced, might have a relationship with the network, will have other things going for. So the only thing that you have going for you as a filmmaker starting off when you're in a co-production arrangement is the story and the rights. And I've certainly seen many situations where a client will land a great story as a subject of a film, will maybe go to a network or go somewhere and they say, hey, if you co-produce with this party that has experience, then we'll entertain this project. Or they may go to another producer and say, hey, will you help me produce this and put this together? And the big red flag is, what are the rights look like? And the minute the superior producing party, I'm just going to just say this is how the wolf sometimes will work. The minute the superior producing party sees that you don't have the right attachment agreements, the right rights all locked up, two things are going to happen. One, you're telling them that you really don't know what you're doing. Okay, that's the first signal. The second signal is they're going to encourage you not to do anything, because what are they going to do? They are going to go around your back once they get the information of who your parties are and get them to sign directly with them. And that usually will mess up your leverage in negotiating those relationships. Because if you're starting out, or if you're an indie filmmaker or a producer and you're working in a co-production manner, your leverage is, at least initially, one, what rights have you locked up? And then two, hopefully you have the skill set to add value to the production beyond the fact that you've just identified a great story. And so when I represent those clients, the strategy is, even though the superior producing party who has the relationship with the network or with the distributor is really going to try to take the lead, we're using the leverage of those rights to give my client a better position in the production. Like, let's say, for example, if it's a television production. In television, the executive producer credit is a very important credit, as opposed to in the film business, the executive producer is typically the financier or someone that has actually raised the money for the production. In television, the executive producer indicates you're either a showrunner or a key producer in it. So in that type of situation, I might be negotiating on behalf of my client with the superior production company to say, hey, we'll let you use these rights. We'll bring these rights to the table so that you'll have the ability to tell the story and go off to the network. You'll be the lead, showrunner and things like that. But this is what we want as my client's role in the production, and these are the credits. And sometimes that can be a knockdown, drag out fight, or, often my client is told that Kirk, the lawyer, doesn't know what he's doing, but typically we get, some success there, and it makes a big difference. So locking up the rights is just so critical. And there will be times where I will tell a client, do not approach third parties about, any type of joint collaboration or joint work without having those rights locked up. Because the minute someone who's more sophisticated realizes that, they will lull you into not doing anything, and then they will actually do that. And then one of the biggest tricks that I see in this business, in this kind of co-production world, and I am spending a little more time on this than I want, but you can probably tell I've been through some of these issues so recent, so that's very much on my mind, is when the superior production company will say, okay, why don't you go get the rights, but use our form. And so they'll send you a form that gives them all the rights, even though you think that you're the one signing them and getting it all straight. So little tricks of the game that you need to be aware of. Again, the chain of title is very critical in the development phase. I'm in a project right now. I'm having a little bit of a drama with an agent in Hollywood, because where my client is acquiring rights to a project that also has some animation and some graphics involved and other things. And I'm anxious to see in the book deal whether or not those rights have been reserved to the publisher of the book, and whether I need to go to the publisher to get those rights, or whether the agent and her client really have the ability to give that to us. And so you have to be really careful, because the two provisions that you're looking for when you're doing this sort of chain of title due diligence in dealing with third-party material are two things. One, the grant of rights provision, and that is what has been affirmatively granted out to a publisher for the book, or a newspaper. I represent someone who writes for the New York Times, and the New York Times has an interesting arrangement when their newspaper articles, people want to, contract those rights out to do a film or TV. And so you have to look at what rights are being granted. And so and then the second provision is what rights are being reserved. And so if in this instance that I'm talking about, I'm dealing with the agent, and the agent is just showing me the reserved rights. And in the reserved rights, it says, okay, it's film and television. So the agent's saying to me, okay, Schroder, we've got these, we've reserved the rights in film and television. Well, if you don't know better, okay, that's fine. But I need to know whether or not the graphic and comic and those rights have been given away. And so I'm now in a little bit of a tiff with the agent, because she's not showing me the grant of rights. So I might have the ability to get film and TV rights, but I might not have the graphic and comic rights, because those have been given away. So in my situation, my client can do a film and TV production, but it can't be something involving graphics or comics, because those have been given away. And I then have to not only do a deal with the author and the author's agent, but I now might have to go to the publisher, which is going to add more costs and perhaps make the project impossible. So that type of due diligence is really important. And if nothing else, when you are looking at third-party deals, the grant of rights, what rights have been reserved, are the two most critical provisions that you must see. You don't need to see the whole contract. You don't need to see how much they were paid or what their back end is or anything like that. But usually when I say to people, just send me those provisions. Either some people are very cooperative and right away because there's really no concern, or some people get very antsy about that, and that usually is a red flag to me. You can go ahead and direct any questions to me. And Jonathan, if I keep yakking, just interrupt me if there's a question. You're not going to hurt my feelings for interrupting me. Okay, we're still in the development phase. We're still dealing with underlying rights, attachment of actors or other key talent. You'll want them to be attached. Now, the typical structure on all of these in the development phase is usually two things. Either one, the right to just shop, what I call the typical shopping agreement. And there are two ways to do this. And I gave you some great materials in your handouts of some shopping agreements that have been negotiated. And actually, you can see my red line comments of the types of issues that either if I'm representing the party giving away the rights, what might be critical, or if I'm representing the filmmaker, what rights will be critical to to hone in on these. Okay, so in the shopping world, there are really going to be two types of arrangements. Well, two and a half. I'll get to the half in just a bit. One is just the idea that, hey, I've got a project. I want to attach you to the project. I don't have the money right now, but if I know I have these rights, I'm going to go shop it. And I'm going to see if I can either get financing or some sort of arrangement to be able to put this together. So the nature of the attachment is you are going to give me the exclusive rights either to your participation, to your story, or whatever it is that I need from you to put this together in the development phase for a period of time, usually anywhere from about a year to 18 months to 2 years. I don't really see these things going beyond 18 months to 2 years. I've never really seen anything go beyond 2 years. And usually if I'm representing one side, I tell the filmmaker's lawyer, look, if you can't pull this together in 2 years, we're just not gonna go there. And so during that period, you can't do anything. You can't do anything with the materials, and I'm going to shop it. And then the first structure of how sometimes these things are done is at the time I make my deal, I'm representing the filmmaker now, with whoever the network is or whoever's going to pick this up, then you can go and make your deal, and you will be reasonable within industry customs on how that will work. So that is one typical structure. There are pros and cons on all of this. It's a very important strategic decision for the filmmaker. Sometimes, as a filmmaker, you may want to lock the party in to terms. And so you have one sample agreement where there are actual terms, and those terms will say, hey, if this is a film, then this is what you're going to get. And if this is a television production, then this is what you're going to get. And the reason why you do that is, if you think the party might be disruptive once they get to a network. So like if you're dealing with someone that is unreasonable, or you think might be unreasonable, locking in all these terms kind of just keeps them in the deal, versus a party who will negotiate in good faith when the time comes. Usually, if you have a deal with the network and you're able to, be on board and sell those rights, the network itself or the major producer will negotiate around you directly with the party. What can go wrong? You could just, depending on what your language is, you could have an attachment, spend a year shopping with somebody, and all of a sudden someone has a change of heart about the whole thing after you've spent a whole year, looking for this, and they just won't make a deal. they'll negotiate, generous terms may ultimately be offered, and the party just becomes difficult. Well, you can't legally force someone to make a deal. And arguing what's in good faith is just a waste of time. And I doubt anyone's going to spend money on litigation fees to try to, to get that done. So if I'm representing the rights holder as the lawyer, I will want to say to the producer, hey, go shop it, go do good. And when you make your deal, we'll go make our deal. Because at that point, when I'm representing the rights holder, I've got the greatest leverage. I'll know who it is, who's involved in the project. Is it a broadcast network? Is it cable TV? Is it some internet channel? And that will help gauge me on what kind of deal I want to make and whether I like the deal or not. And on the other side, if I agree as the rights holder to fixed terms, then at the beginning, before you're shopping, I want to be careful not to undercut myself, because I might negotiate at one economic level, and then all of a sudden you've got to deal with NBC. And if I had not locked myself in the beginning at this level of payment, and I knew that you were going to be with NBC, a year later, I would have negotiated a whole different deal with you, or much better deal. So there's a pro and con to that. Usually when you're locking in terms, you're usually paying someone for some sort of shopping period. It could be the idea of an option. You could, if you're in the attachment and just going to let someone make the deal at the time you make yours, you're usually just making some nominal payment just for the exclusivity period. If you're locking someone into terms, you want to pay them for an option, which is, again, the exclusivity term, but the option to purchase. And then you actually have the purchase price as well as any of the other terms that are associated with the deal already locked in. So at the time you're ready, all you're doing is either you or the funder or the producing partner will actually just go ahead and cut the check. And the minute that check is cut and cashed at the bank, all of the rights transfer and the contract has kicked in. Let's see, I got my first question. Have you ever seen any issues with paying non-fiction protagonists, story rights, location fees, etc., with entities that don't allow you to compensate? Jonathan, why don't you unmute and explain that question to me? I'm not sure I fully understand. John, excuse me. Will you unmute and just explain your question a little bit further for me?
Absolutely. And thank you so much for doing this, Kirk. This is incredibly helpful.
I'm going to fire hose y'all with a lot of information, so stay with me.
Oh, it's amazing. I'm curious. So there's kind of a conversation I've heard with nonfiction filmmakers where we say, you can't pay subjects. You can't pay anyone in a documentary. Anyone who's going to take it is going to nail you for that. But we're asking people to spend days with us, share their stories with us, relive events in their lives. And so there's lots of filmmakers who'd like to offer something to compensate them for their time and their efforts to participate.
Yeah, John, this is an excellent question, and thank you for raising it. So for documentary filmmakers, if you're compensating the participant or the subject of your documentary, then there's a real legitimate question as to whether you really have a true documentary, because you're paying somebody and you don't really have that journalistic documentary integrity, and there will be some way back up, there are networks that will have a policy where in your distribution agreement, they will make you represent and warrant contractually that you've not paid or compensated anyone. So the question is, how do you address that? Well, there's nothing wrong with covering people's expenses. But they have to be legitimate expenses. You have to document those, and they can't be excessive. And I always warn clients in this area, don't just write a blank check. If someone just says, I would not do, let me put it this way, I would not do like a per diem, type of thing, or anything that lays question that there is a benefit other than, other than paying for legitimate direct expenses. What are direct expenses? Meal, travel, anything that is necessary that is incurred by the third party. Ms. Holliday's question, what's the law on paying? There's no law, okay? It only speaks to the integrity of your documentary, all right? It only, I've certainly had situations where I've seen this great documentary, but it turned out that before it came to me, the client, paid people, compensated them, thought that would no ill will, there was no hidden agenda or anything like that. They just, wanted to take care of the folks. And it does then take away the integrity of the cooperation. I had an independent filmmaker documentary client, and a great story about, back, I think in New York, when certain religious charities were splitting up twins and triplets in different houses at birth, unbeknownst to each other, and as part of experiments, and just what the impact were of those kids that were split up that never knew they were a twin or a triplet and had other siblings. And one of the subject matters wanted money. Just said, hey, and we were in theory going to be bargaining against the BBC, because the BBC was interested in this story. And it was a very tough situation, but fortunately for the client, she just said, I'm not going to ruin the integrity of my documentary production by paying the subject, one of the subjects of my documentary, and being open to question. And so we didn't make that deal. We had to work around. We had to go to public information and things of that sort. One other thing I'm going to just talk to in this phase is, it's important to get clearances. If you have a script, you want to hire a script clearance company to read the script to make sure that you're not subjecting yourself to claims. So, like, for example, if you have in your script, just by accident, okay, a character, someone named Kirk Schroder in Charlottesville, Virginia, okay? There just so happens to be a Kirk Schroder in Charlottesville, Virginia, and I might, when people see your film, people might be calling me up and say, hey, I didn't know that was you in this, and you would open yourself up to potential claim by me on a violation of right of privacy, right of publicity, because there's you referring to a Kirk Schroder in Charlottesville, Virginia, and people can reasonably identify, and whatever the inference is. Of course, if you make me look like a hero and a superstar, it probably won't matter to me. But if you have me doing something bad, then I might be a little upset about that. Anyway, so script clearance is important. What does script clearance do? Product place, any type of references to product, names of actual that you might run across of actual people, other things that might be libelous or slanderous or important. And there's some great easy script clearance companies to do that. Sometimes I get hired to look at particular scenes to determine if they are slanderous or if they are, people like to use the term fair use. So I'm going to knock that out very quickly. first, let me talk about libel and slander, okay? Just very quickly, all right? First off, libel is affecting someone's reputation. It is, and it has to be a fact, not an opinion. So when you say that Kirk Schroder is a jerk, okay, that is an opinion, all right? And I might not like it, but generally the law will say that you have a First Amendment right to say that Kirk Schroder is a jerk, and that can be an opinion. If you say that Kirk Schroder is a bank robber, okay, that will speak to my reputation as to whether I commit crimes or not. So if you say that Kirk Schroder is a bank robber, you better have the date and when and the information on when Kirk Schroder was a bank robber, or you are libel or slandering me. So this is the most important thing that you need to understand in libel or slander. Truth is a defense, okay? So if you have the truth and can document, and you're making these assertions, let's say Kirk Schroder is a bank robber, then I might not sue you because I might know that you are correct in that, and I might not want to go through that. In fact, I've had clients consult me in these libel situations, and one of the obvious things, the most obvious is some sort of infidelity. And I will say to the client, okay, you understand that if we file suit and we claim that you weren't really you weren't cheating on someone or anything like that, that you're going to get questioned about that in the discovery phase, and that all is going to be an open book about you. And do you really want to open the door on those sorts of things? I represent Beth Macy, who wrote the book Dope Sick, which is the Hulu series with Michael Keaton right now. And Beth is a journalist and very well documented. And she really gets into the opioid crisis, and points fingers and does all sorts of things along that line. And we get letters. It's not uncommon that we get a letter from someone who's not happy with what she has presented, but it only goes beyond the letter phase. And the letter is just, we're watching you, no one's even accusing us that she's not telling the truth. So that lesson, if you will, on libel and slander, again, I'm going to fire hose you with a lot of information here. So just throw questions out as you will. The other thing is in this development phase is fair use, okay? If I had a nickel for every time someone client comes to me and said, oh, this is fair use, okay? That word is so abused. And I'm just recommending to everyone, do not abuse that concept, because there are a lot of people that have thought this is fair use, and their idea of what's fair and what the law says is fair are two different things. Fair use is a copyright concept. That means that you are using someone's copyright. You're infringing on their copyright in a manner that, because when you weigh First Amendment and other free speech rights, that is okay. But it does not give you the right to take away the commercial value of what you're infringing or what you're taking. And so fair use is a question, it's a test, and it usually comes for this audience, it usually comes in a variety of situations. One, if something is educational, or second, social commentary. So usually if you're a documentary filmmaker and you're making some social commentary about something and you're using it, The other are news clips, news, situations. I'll just give you some quick examples. The major case on fair use, the U.S. Supreme Court case, involved Roy Orbison and Two Live Crew. I think that's the band. But anyway, Two Live Crew did a song on Pretty Woman, which is a Roy Orbison song. And Roy or his estate were not happy with that and sued and said, we didn't give you the rights to use this. Well, I don't know who the lawyer was for Two Live Crew, but they had a very interesting argument that this was what they were doing was fair use, and in particular parody. Okay, so the argument was that Two Live Crew doing Roy Orbison's Pretty Woman song was a parody of this, and therefore it was a social commentary and things of that sort. And the U.S. Supreme Court disagreed with that because it basically said that you're not, parody is making fun of the very thing you're criticizing. Okay, here there was no criticizing, they just cut their own version of Pretty Woman and didn't have the rights to it. The best example of parody that I know out there is Weird Al Yankovic, which I think, looking at myself today, I might actually have a resemblance to, because Weird Al Yankovic actually makes fun of the very songs he's parodying. That is, the work that he does connects directly to the subject matter that he's making social commentary on. So clearly a fair use thing, as opposed to just recutting someone's music or taking it away. Remember, in fair use, if you're taking away the value of that, so like, let's say if you are using a film clip and the film clip is the critical portion of someone else's work, then you still have you still have to justify why it is you're using that clip without getting permission. My friend Cahill says that Weird Al still gets permission. That would not surprise me. Probably he gets it because he's so reputable these days and just doesn't want to mess with it. But my guess is when he is getting permission, Cahill, that the permission is not being given without the other party seeing what he's going to do. Okay, so there are going to be, and you raise a good point, there are going to be circumstances where you don't want to get permission because what you're commenting on, it might upset the other side, but your commentary will still have social value and an important value. Like if you're doing a documentary on a murder case or some sort of criminal activity, or you have a political or things of that sort. So you have to be very careful with fair use. De minimis is another concept. That is, if you use something very, just a small portion, that is that the work was so de minimis. I usually see this when we have rights to a clip and the camera is screening and there's a piece of artwork in the background, and for like 3 seconds, that art is in the shot. Okay, it has nothing to do with the story. It just happened to be there. That's an example of something that's de minimis. Okay, and that's an argument that is de minimis, and someone that would make that argument at contrary would say, no, that artwork made the production. What are you talking about? That was so awesome. My favorite de minimis case was I represented a well-known beauty pageant winner. And, as beauty pageant winners go about, they're cutting ribbons and doing things. And beauty pageant winner had a stalker who, like, all during her reign would take photos unbeknownst to her. And as a gift toward the end of her reign, okay, stalker went to beauty pageant winner and said, here are these photos, for you. I want you to have them. And beauty pageant winner, was grateful and this and that. Well, unbeknownst to beauty pageant winners, because they didn't go to law school, and thankfully that they didn't, I'm going to get to that question in just a second. A beauty pageant winner was given like a page in the program of the pageant where they were going to crown beauty pageant winner's successor. And in that, beauty pageant winner put a few photos in this one page of the program of the pageant, okay? And good Lord Almighty, there was a big federal lawsuit. Beauty pageant winner was sued for copyright infringement. We were in court, and my argument to the judge in the pretrial conference was, what are we doing here? You're talking about a photo this size and one kind of like this on a page of a program for a pageant. This is clearly de minimis. This is what was this incidental? And it's always a tough call for a judge, but we ultimately could not pass. The judge let it go, not kept the case going, did not accept my de minimis argument, which I obviously disagreed with. But fortunately, beauty pageant winner cried enough in the courtroom that everyone had had enough of it, and we were able to settle it. But the stalker essentially had another agenda. So this sort of de minimis thing can be really tricky. Let's see. Okay, clips used in social media. Remember, when you're putting stuff up in social media, you are agreeing to their terms and conditions. So like when you put something up in Instagram and you put something up in Facebook or LinkedIn or TikTok or wherever it is, that's the minute you do that, you have accepted their terms and conditions. And so I would really suggest that you take the time to look at those terms and conditions before you do something like that, because you may be giving away something that you don't, YouTube especially, you may be giving away something that you don't intend to, and you can't take it back. Yes, the stalker did sue her right after the gift. We were in federal court of all places, and was asking for statutory damages per instance, so each program that got sold had a statutory damage amount attached to it, which is what the stalker. So what you do to 20-something-year-old beauty pageant winners when you have nothing else better to do. Okay, let's see. One more question. I'm going to move us out of the development phase. I've spent quite a bit of time there, but hopefully worthwhile. I just completed my first documentary with temporary music. I would like to seek commercial release. How do I get started securing rights? A great question for song. There are music clearance companies, which I think begs the question, as a filmmaker, there are some great services out there with script clearances and music clearance companies that will very effectively and affordably do this sort of clearance work for you. I mean, I think you just have to go and get quotes from those sorts of companies. And there are a lot of people out there that do it, that know the routine, that know how to negotiate those rights for you and determine it. If you're on a budget, then either use music that's in the public domain, and that's easy to do research on that, especially if you're doing background music, or use Creative Commons license music. And there's a website that you can obtain that will give you access to music that can be licensed for free in your production. And usually the main condition is that you give credit to the creator of the music. So there are lots of ways to navigate getting those sorts of rights, but that's a great question. If you copy someone else's social media post without permission, it's not exactly fair use or public information. I've had companies for profit repost my photos on their page without asking. So the issue, it depends the nature of the photo, okay? Like if you're using someone's name, image, or likeness, typically that is not permissible if it's being used for a commercial purpose. So you can approach that party on behalf of the subject matter, the subject, and say you don't have rights under right of publicity, right of privacy laws to repost this. If it's in an ad, I mean, usually if someone's just reposting it and going, "Oh, this is a beautiful shot of the moon," and that was the photo that you took of the moon, it's really not. It's not worth it in terms of going after it. But like if you're reposting a music video, then arguably you're affecting the sales of that music, because all someone has to do is go to your website and listen to the music on your site, and that's not necessarily a good thing. So there are different examples on that. One more question, and then let's see. I've had companies for profit repost my photos, but if they're doing the posting for commercial purpose, then you clearly have a claim. Okay, but you have to make the argument of what the commercial purpose is. That argument is their advertising, their marketing, something along that line of promoting their business. If they're just kind of congratulating you, that's you may not like it, but arguably they're not promoting their product or doing anything. They're just kind of giving you a congratulatory post, which my company salutes you kind of thing. If they were using it for marketing, then yes, you have a claim. Is there a difference in music that's being critiqued in a film versus background music? Yeah, the music that's being critiqued is the subject matter, and that is arguably fair use because you're critiquing it. You're giving some commentary on it. Hopefully, you are actually critiquing it, not pretending to critique it in order to allow everyone to have the listening experience. So that is a case-by-case basis. Background music is just background music, and that still has a monetary value, and you would be infringing on people's rights or the artist rights if you didn't have rights to the background music. Why is it hard to get clearances out of newsreels from networks? I just finished a documentary. We're going nuts trying to get network news clips to old clips. Mainly the volume. I find that a lot of networks just don't have the infrastructure and don't want to mess with it, because especially if they don't think you're going anywhere. Michael Moore, who's obviously a famous documentary filmmaker, will have no problem getting rights because they go, "Oh, it's Michael Moore, and he already has a distribution deal with X, Y, and Z, and this and that." And so you have to remember, one of the things that the licensor is going to determine is whether you're worth their while to give a license. And so when you're approaching a potential licensor about something, you don't want to just ask for it. You want to kind of like make the case that this is going to go somewhere. This is a project that's got some legs, got some wheels, or whatever. And it just can be, hit or miss. There is info on the websites about policy and terms. It's very hard to get their licensor to get a license. Or there are specialized services that will help you get that if in the event that you don't. Again, I highly recommend these music clearance, film clearance services, because they not only identify who the rights holders are, but they'll actually help you get those rights and negotiate them. Okay. I ramble on. So that's all I'm going to talk about, the development phase. I could talk a whole other afternoon on this, or morning, but I won't. Financing. The easiest financing is your parents. I have had situations where parents have put up $400,000 or $500,000 for a project. I'm not saying that everyone can do that, but I just want to make that a tip known in case you can get there. But for those of you that don't have parents that will put up $400,000 or $500,000 for you to make your own film, financing really is just a broad range and will just come in so many different ways. I could just spend again another morning just talking about financing structures and how to do that. And I'll certainly field any questions that people have in this regard. The classic financing situation that's always been the case is usually if you have a famous actor or famous talent attached to a project and you have a great script and you have all these other elements, you can go to a third-party financier. It might be a distributor, a studio, and say, look, I have all these attachments, the things that we've talked about in the development phase. And if I can deliver all this, will you distribute it? And the distributor will go, yes. And we will give you an advance on that. So we will, your project might be your project, might need, let's say $1 million, and the distributor will then advance you $1 million for the rights to actually make the film. But in that, what the agreement will say is, by this date and time, you will deliver a film that has all these elements in it, and we're advancing you $1 million. And then what the distributor will do is actually then flip the film either to make more money, depending on what rights have been sold. So like I will have deals at times that will be part of pre-sale of rights. We might pre-sell European rights, but we keep North American rights because that's where we think the commercial value will be once it is out in the marketplace. Or sometimes you don't have the benefit of that, and you might have an advance party that will say, we want worldwide rights, and you're kind of just locked in to getting that money and hoping that you've built in your budget and other things that will get you there. It's not a common thing these days. This is, on the independent market. Sometimes, like I had a client who was a short film director in New York, and because she did just short film, she couldn't get anyone to sign on with her for a feature film project. And because everyone's like, oh, it's one thing to do short films, but does she really know how to do a feature film, and and all this sort of stuff. But fortunately, she knew two really famous actors, and as a wedding gift, the two actors said, we'll be in your film, your feature film. And so we were able to go to a distributor who were really enamored with these actors and say, hey, we've got these actors attached to a great script. You're going to let my client direct this, right? In return for this. And so we ended up negotiating that. But not everyone has famous actors that will give you that for a wedding gift, but that's an example of how you might get that situation. So I'm not going to get too much into pre-sales because I don't think it's a common thing unless someone pops a question. Company names, Whole Foods, street scene shots. Again, it's just de minimis. If you're shooting a scene and it's a 5-minute scene and there's a Whole Foods sign right there, you better blur it out, because at some point you're just using a Whole Foods trademark like for 5 minutes or 6 minutes or 2 minutes or 3 minutes, and Whole Foods may not like your film and may think that they don't want its trademark to be associated with that. I had a film, a baseball film, and it had some little controversy in its scripted production. And we were trying to get MLB to give us the rights to a jacket that had baseball team logo in it. The scene, was a tough scene in that the actor was a very emotional scene, but the actor had a baseball jacket on with the team logo, and MLB didn't like the scene. MLB said, no, we're not going to give you the rights. We had to blur out that logo of the baseball team. So it's one thing if it's a passing shot, I don't think anyone's going to go crazy about that. But if you're like, it's there and it remains there in the scene, then you're associating that brand or trademark with your production, and you better be very careful about that. Is there an issue having company logos on the shirt of interviewees? I think I just answered that. Well, in a documentary, I mean, yeah, that person didn't have to be wearing that company logo in the documentary. You could have asked the person to wear another shirt or something like that. And especially if it's a documentary about a subject, if the logo relates to, well, my favorite might be the girl that gets on the mic at Walmart and tells everyone to F off, I quit, type of thing, and she's got a Walmart thing on. That arguably is part of the subject of the documentary, right? Because there's a social commentary about how Walmart treats. Now watch, be Walmart employees on my thing, and I'm going to get some nasty grams here, but arguably Walmart would be the subject of that type of documentary. So having the logo there is no different than anything else. But if it's just talking about some other controversial or subject of social commentary in the documentary, and there's a Walmart logo there, what relevance does that have other than you're associating Walmart with that on the shirt? Tell them to change the shirt or blur it out. Okay, getting back to financing. Most of the time in your situation, you are going to be trying to finance by investors. And you really, at the outset, you're offering investors two scenarios. One is an investment in the profits of the film. And that's just a classic investment agreement where you're saying to the investor, hey, for your money, whatever revenue I get based on this formula, and I'm going to talk to you about those formulas in just a moment. You're saying to the investor, I will, pay you out, and as money comes in regard to this. So that is, I usually just call that an investment contract situation. The second scenario is very common, is you're giving the investor equity. Okay, so that means that you have an LLC or corporation that is technically the owner of the intellectual property that we've all put together. We've copyrighted, attachment agreements and everything, script in the development phase, and the investor has a stake in that. That means the investor has some stock, or in the LLC, it would be a membership interest and certain rights under a operating agreement. And depending on the sophistication of the investor, usually most investors want stock or equity because it is technically ownership in the project versus just a contractual contractual contract, because in that scenario, the investment is only as good as the contract. Okay, so if the investor has a crappy contract, then those rights are very limited. Or the investor has this knockdown, drag out, I'm in control type of contract, then that may not be such a bad thing, versus equity, where usually if you own equity, even if the contract is missing things, just by virtue of being a stockholder or shareholder, by law gives you certain rights, under various state statutory schemes. So that's really one of the first things that you need to be aware of when you're trying to finance a film. I'm just looking real quick. Yeah, I think I've got all my questions covered here. So remember, and this is very, 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 very important, if I didn't say it was very important, that when you're offering an investment, you are touching on security laws. That is that you cannot just offer investments ask people to invest without either potentially running afoul of state security laws and or federal security laws. Because as a general proposition, and it's a Supreme Court case called the Howey case, where someone sold interest in an orange grove and said, hey, if you give me money for me to set up my orange grove, I'll give you back profits. And when that investment went wrong, the owner of the orange grove said, hey, this wasn't an investment. There's no stock. There's no membership interest. I don't know. It's just an orange grove. And the U.S. Supreme Court said, no, when you are asking someone for money and there is an expectation of a return on that investment, that is an investment. And you must therefore comply with security laws. And that can be a blessing and a curse all at the same time. I'm going to try to, let's see. Question, brand names, cars, and film scenes, is permission needed for showing the car brand? Again, it just depends on how it's a judgment call. Is it incidental, or are you like featuring the BMW throughout the whole film? You know, if it's incidental, and I doubt you're going to have trouble. But if like the car in the film is a BMW and you're using logos and things like that, BMW may say, we don't want our brand associated with this film based on whatever they think of your, also Ford vehicle versus Tesla, this may have been answered. I think I've answered it. Incidental versus, is it the focus, or is it enough of a focus that people would associate the brand with the film? First time feature, what's the best route to find investment as a producer? If I knew that, it's really, it is going to be the basis of your film. I would just say very quickly that the more niche you are, like let's say if you're doing a film on tennis, and you've got great attachments, great things around the tennis world, then that's a you know, there's a niche audience for that, or for rugby, or for soccer, or horror films. The more niche you are, the more general, like rom-com, those sorts of things. I just think you gotta just, you know, find people that see something of commercial value with what you're doing. Remember, no one's going to invest in anything unless they love you, and they just, you know, they grew up with you and they think you're awesome, or they think you have talent, or they think the project has something going for them, like an amazing story, you know. And that's why, again, I emphasize locking up your story, locking up your rights, all in that development phase, and really owning it contractually makes all the difference, because you just may have the heck of a great story and nothing else going for you, but that might be the basis of leverage to be able to do these other things. So getting back to security laws and investment. So the general legal, I'm speaking very generally right now, because again, I could, and I think Jonathan knows, I could just do a whole program on just financing your film and just all the different things all on that line. So I'm going to be very general with you here when I say that, as a general rule, when you offer an investment to someone, you have to register that investment with the state in which that person is offered, and or you have to at least file some paperwork at the federal government level. And at the state, they're typically called blue sky laws, because you're offering the blue sky, you know, to people, and the states will regulate that. Now, the benefit of registration is that if you properly register it, you then are generally protected to some degree or another from lawsuits that may come where people might accuse you of securities fraud or things along that line. Now, as a general proposition, it's very expensive to register a security. Therefore, state laws have an exemption. And if you meet certain qualifications, which I'm going to just guess right off the bat that everybody does here, Can you lock up an idea for a documentary film in the development phase? Yes, by contract. And I would just refer you back to my earlier discussion on this. You can, if you can identify the idea, usually I would put it in a treatment or some other, tangible means to say this is the idea and everything, and it's coming from this party. You can lock that up. Just make sure you have a really good confidentiality clause and a non-disclosure clause in that agreement. So getting back to security laws, you're not going to register a security. You're going to look for an exemption, okay? And the exemption is going to come in two forms. There's certain states that say that if you have friends and family, that means if you can document that the people you're getting investments from are either business colleagues, friends, or family, and they are fewer than a certain number, usually that number is anywhere, depending on the state, I would say between 10 and 15, then you don't even have to file any paperwork with that state because that will be exempt automatically. That type of investment from a state a registration for exemption would be exempt. And but even in those agreements, I will still put a lot of disclaimers in, just to protect yourself contractually. But most of the time, you don't have that. You are going out and trying to, just get outright investors. And usually it's done in a form of a PPM, a private placement manual. And the whole idea of a PPM is you're basically selling the investment, if you will, to a party. And usually the PPM will have a business plan, an explanation of the producers, who the talent is, what they think the market is, and kind of any other useful information. Of course, the classic PPM is the one that takes 4 weddings and a funeral and go, look how great 4 weddings and a funeral is. We're just like that, these sorts of things. So I'm going to get into crowdsourcing in just a bit, but the thing I just need to really emphasize to clients is that disclosure is the key in any type of investment pitching. And usually the purpose of the PPM is to have enough disclosure that protects you from a claim of securities fraud or some sort of misrepresentation if the film doesn't make money back for anybody, versus having enough appeal that someone will invest in your film. Now, and this is me on a high horse, so you'll just have to forgive me. There are lawyers out there, okay, who will give you these cookie cutter PPMs, and they will absolutely 100% protect you because they have every disclaimer in the world that you can imagine. And but no one's going to invest in your project because why would they? It's just so awful. It's just so scary. And they'll cookie cutter it for you and add their name and stuff like that. The real PPM is done thoughtfully. Yes, I'm going to get into Section 181 in just a bit, and I'm sorry if I missed Mark's question there. The real PPM is done thoughtfully, where you say, these are the things going for the film project, and these are the risks. And overall, investor, we want you to take that risk because we think that the positive things will outweigh that. And that's the thoughtful PPM. And the thing about these exemptions is that the amount of legal work that it takes to do a PPM for film for $200,000 is the same work for $2 million. And sometimes I'll tell clients, you might as well ask for more money because you're going to need some of it more up front to cover some of these things. It's not triggered on a dollar value. It's triggered on how many people are being offered and where they're located to. So as a general proposition, I will say to a client, the fewer states and the fewer investors, the easier it is from a legal and cost standpoint. the more investors you have in the more states, then we have to go to each of those states and make sure we're complying with each one of those state laws. For like, if you have one person in Wyoming, I might say, do you really need that person in Wyoming? Because if we have to do Wyoming, this is what we have to do with Wyoming. And then that might be contrary to Tennessee and what needs to be done in Tennessee. So we got to jump through the hoop in Tennessee, and then we got to also jump through the hoop in Wyoming and wherever else you have to go. But sometimes that's just the way it is. You can't, you just have to live with where you think your investors are. Usually what we'll do before we get to a PPM is we'll have a term sheet, and it'll just be a discussion document. And so usually what you'll do is you'll create a term sheet saying to the investor, this is what I'm thinking of doing, and this is the discussion document. If I put together the legal paperwork for that, would you be interested? And you kind of feel it out. I think it's a mistake at times to just go hire a lawyer to put together a full-blown PPM, and because you don't know if people are going to take the investment or not. And then usually what happens is the investor comes back and says, if you change these terms and these terms and these terms, I'll do it. So then you got to go back and change terms in the PPM. And then another investor says, change this. So usually if you have a discussion document that's just kind of like a term sheet with the key terms, that's usually where you want to then feel your audience out. And then you want to go to the lawyer and say, hey, I think I've got a pretty good feel on this. And if I draft the documents this way, generally I'm going to get my investors and go from there. Disclosure is key. Misrepresentation is a no-no. What do I mean by that? Some folks at times will misrepresent distribution. If I'm representing the investor, and I do represent some sophisticated film investors, that means they look for sophisticated projects. One of the obvious things we look for right off the bat is there any distribution? I mean, is there a revenue stream that could potentially come? Now, just because there isn't doesn't mean that someone won't invest in it. But if you don't have some sort of distribution, which most of y'all will not, I'm guessing, in this audience, then you want to say, look, we're going to go spec it. We're going to go shop it to film festivals. We're going to enter it in Sundance or Berlin or Toronto, wherever we're going, Cannes, and we think that we have the ability to get there because of this, this, this. In other words, the thoughtfulness of the marketing plan, it can also be a selling tool, obviously will be a selling tool for evaluating the potential of the film, even if there's not an existing distribution deal. Where things get tricky on the distribution side is this. One, sometimes some people will attach a letter to the PPM, and it'll be a name of some distributor, and they go, we are happy to grant you a right of first look. Okay. And I'm like, what is the right of a first look? Okay. So it absolutely means nothing. Okay. Zero. Distributors can have the right to look at your project first. Okay. But it can be very misleading because that dentist or that podiatrist who's investing in your film might think, oh, that's a distribution deal. Okay. When it's not. And that's the type of thing that lends you into lawsuits and securities fraud and things like that when you're misrepresenting something. I got fired once by a client who we were talking to distributors. And when I'm talking to distributor, and I'm obviously overlapping in some of the distribution phase, but we're almost getting to that half hour left where I want to make sure I cover that. I'm going to take a few more minutes here on the financing phase, where you got to ask the distributor, what are the models? Where are you going with this? In a lease case, in a moderate case, in a high performing case, what do you think this project can do based on what you're offering? And an honest broker distributor will tell you, this is this, this is that. So when I was doing that type of due diligence, it was very clear from the distributor that even in the utmost high performance, this is a great film for the distributor scenario, the film would still not make its money back for investors. So I had to say to the client, you really can't go represent this distribution deal to your investors as this is distribution, when we know inherently that given the rights that we're giving, that we're even in the best case scenario, you're not going to make the money back for the investors. And that is misleading. So the client didn't like that, and I got fired. And I was happy to be fired on that point, because that presents problems. And when you get sued for securities fraud, it's not a fun venture. I had, when it's done right, I represented two old ladies from North Carolina who put $600,000 of their life savings, $600,000 of their life savings into a film project that was just completely a bunch of baloney. But they had a lawyer who knew what they were doing, who locked up every little element of it, crossed every T, dotted every I, however you want to say it. And they lost $600,000 of their life savings on a film that really had no, from a market value and from a economic value, had little to no potential. And I shot at it every which way. I tried to crack the armor, from a security standpoint, but they had all the right disclosures, they had all the right things. They couldn't be accused of any securities fraud. They just had two sisters, little ladies, who gave up their life savings because they didn't know any better, and were convinced somehow that, by the charm of the people, that they were going to make their money back on a $600,000 investment into a film. So even if this is done correctly, you can still cheat out $600,000 out of two ladies who lost their life savings in North Carolina and live to talk about it. So these things are really important in this phase. Investment wise, I'll get to this question in just a second, but let me get this point out before I forget it. Typically, if I'm investing in your film, and I say I'm representing an investor in your film, I want to know, are you paying yourself? Okay, are you in the budget? And that cuts both ways. Sometimes I'll say that's a good thing because I want you to make the film. I want you to eat. I'd like for you to go to bed at night and have a roof over your head and things like that. So that's not necessarily an objectionable matter item, but the question is, how much are you paying? What does that cover? And is that reasonable? And if I find that you're paying yourself, then the type of return that I want is going to be much greater and more substantial, because I am really now taking more of the risk, and you're not having but so much skin in the game, because generally speaking, your costs of living and things are being covered. If you're not paying yourself, then I am going to be a little more flexible on the terms and conditions, because again, I want you to eat, but I also recognize that you're putting sweat equity into the project. And so that's a really important negotiating point that you need to be aware of when talking with investors. Typically, an investor will want a preference in payment. That is, that you want them to be recouped first. And that can either be 100 cents on every dollar that comes in, or a split of like 70-30. Usually the 30 going to the producer or the filmmaker, because they're not getting paid anything, and they do need at some point, as money comes in, some money to pay the bills and things like that. But usually there'll be what in these agreements, a preference. You'll say that you get recouped first, and then an interest payment. It can be compound annually or a single payment. If I'm representing the filmmaker, I will just want a single payment. One, could be 10%, 20%, whatever it might be, of the original investment, and then a split of profits thereafter. And there's usually some variation of that formula, and that is covering all revenue streams that may come from the film. Obviously, you can reserve streams, you can do things like that, but that's typically a formula, and that's how that will work. An interview provided 2 videos that 2 astronauts submitted for a spouse's funeral. She asked me to include them in my documentary. After the fact, she changed her mind and asked that I not use the footage. No paperwork ever signed. You don't stand anywhere. The transfer of a copyright or a license by law must be in writing. So if right now, or it must be in some tangible form, if I'm giving you verbal permission to use my copyright or license and I revoke that, I'm well within my rights, and you're in deep trouble. Now, there is an argument, an estoppel is what we call it, an argument that say that, you know, I went so far down the road with this. So in this scenario that Kevin White is presenting to me, he might be able to argue that there was an estoppel, that he relied on this in such a way. And she knew when she gave that permission that he would be relying on it, that to take it away from him now would be unjust. It's not the argument you want to go, you know, hang your hat on, but there is an estoppel argument, and the courts will recognize it in those circumstances, but you generally just don't want to be in that situation. You always want to document your license, your rights to use anything. And even if someone's being just nice to you, even if you just write on a napkin, you know, I hereby give you the rights to use this footage in my thing, you know, for good and valuable consideration, that's enough. I'm in a court case right now where we're arguing over whether or not an e-signature, an accept, constitutes a signature under copyright law. It's a very fascinating case, a little complicated, but we'll get there.
But the digital kind of, what about the digital part of they sent it to me in an email with the attachment, use this, but there wasn't like a contract. Does that?
Well, did they actually use the word use this?
Yes.
Okay. Well, so you do have permission. So the question is, can it be revoked or not?
Right.
Okay. So you're in a little better stead than I thought your original question. You can use it. You have permission, but now she's revoking it. And since you didn't pay her $1 for a contract, remember these things, I just want to emphasize to everyone, you don't have to pay someone $1, but if you just use the phrase for good and valuable consideration, the receipt of which is acknowledged, for good and valuable consideration, the receipt of which is acknowledged, you have told the court that there's an exchange in a contract. In this instance, you have a unilateral permission that could be revoked, and you still have the estoppel argument in your favor. So that's the best. If you want to talk more offline, I'm happy to do that, but that's generally what I would say to you. So I was talking about what the investment terms are for an investor. So there is section 181 under the federal tax code. I'm not going to get too much into tax law, but essentially, this is just nothing but about what can be deducted if you're an investor in a film project. It's an incentive from a tax standpoint. And so simply put, you can use that as a selling point to the investor, but it's something that the investor's counsel or accountant will want to advise them on. I highly recommend that you make the investor aware of 181. Basically, that would allow them certain deductions off of their taxes if they put money in your film, but I would not be giving them the tax advice for hence that you would be committing fraud or misleading them by getting them to rely on something. So usually what I tell my client is, if you're going to try to pitch a 181 deduction for them, make them aware of it, send them the general information, but urge them to talk to their accountant or their tax advisor and be willing to encourage that, and then let them come back to you and say, I talked to my tax advisor and they said this is a go. So yep, you're good to go. You've not misled them and you've not misrepresented or done anything on 181. The other tactic that I see in this area, and I haven't gotten into crowdfunding, I still got some time here, is people that will do a nonprofit. And remember, if you do a 501c3 and you want to collect money for donations, there are a lot of strict laws that will have, tests on whether your nonprofit's legitimate. And so you're usually getting a nonprofit for educational purposes, which would cover the documentary film area and things of that sort. So your film project has to be educational, like, for example, I just recently, maybe within the last year, represented a project that told the story of a federal judge that was involved in many controversial decisions during his tenure on the bench. And it was qualified as a nonprofit because it was educating the story about social history, social commentary about events going on in the 1960s and 1970s. But that nonprofit entity owned the film, not the filmmakers, so there's a lot of paperwork, because what happened was you have the nonprofit that has to own the film, and then you may have people on the board who are the filmmakers, and you've got to recuse them. And then you have to have an agreement with the nonprofit and whoever's going to make the film, and all these sorts of other things. So there are a lot of hoops there. And not too long ago on another project, a client called me up and said, we've got this nonprofit, we have these nonprofit assets, and I'd like to just, since I made the film, I'd like to go ahead and buy it from the nonprofit. Well, that's great, but now someone has to determine the fair market value of that, and it can't be you, client filmmaker, who made it, because it's owned by the nonprofit, and you've got to be recused of it. And so usually, if there are people on the board that are involved in the project, they've got to recuse themselves. And usually what I'll do is I'll just tell the client, resign the board, get independent people who are on other nonprofits, and they will be proactive in bargaining with you on what they think the fair market value is for the project, because then they'll go dissolve the nonprofit and disperse the funds to their nonprofit. So that's one easy solution. Okay, kind of like a section one. This must be the 181. Thank you for that. I don't want to get too much into 181. It is a deduction, a tax deduction, and it gives you certain benefits in when and how much you can deduct in a film project, and stuff that you can easily find offline than what we have in this lecture. Let's see, anything else on the investment side? Crowdfunding, yes. So nowadays, you can crowdfund investing a film, the classic, the Indiegogos, the Kickstarters. There, you're not getting an investment. You're just giving someone T-shirts or hats or some sort of merchandise or a credit in the film. If I put $25,000 into your film, I can be an executive producer credit. I don't want to say a whole lot about that because it's pretty self-explanatory, and you just live by the rules of the website that is providing the services. The twist in federal law is that now federal law will allow the crowdfunding services to actually crowdfund equity investments or monetary investments for return in a film. So I have clients now that are checking out crowdfunding sites where, for $5,000, they'll get a certain percentage ownership in an operating agreement that will own the film. And those sites then become the brokers and make you jump through a bunch of hoops in compliance, so that they're in compliance with federal laws. And they will also have caps on how much you can raise. There are a number of them out there. They all have different schemes of how they work. They are effective. The thing, again, I just emphasize to you, you don't want to misrepresent your project. You don't want someone coming back and saying you did not. The issue in this type of investment world, just as what I've discussed before, is if I knew this piece of information at the time I was giving you money for my project, I would not have invested. So you have to always ask yourself, is this very material? Is this a material piece of information, for your project that you might have an investor? And sometimes if I have a situation where there is a development that's not been disclosed, we then have to write back the investors and give them the right to rescind their investment. I've never really had a situation where when I've had to do that for a client, investors have rescinded, but we've had to cover ourselves by giving them that right and having them affirmatively say, no, I'm not going to rescind. We still believe in the project itself. Usually it's because a distribution deal that was disclosed early in the early phase has fallen through, and we're having to go back to the drawing board. And usually the client is calling investors and telling them verbally what's going on and setting the stage for them to sign a document that says, I'm aware of this now, and I'm not rescinding the investment. But the crowdfunding phenomenon is really big. I've got a number of clients that have had good success with it. I don't know if they've made so much money for their clients, but I'll just close the investment phase by simply saying that, if you can't convince the investor that you're out to help them make their money back, then the whole tone and environment of you getting investment is just unlikely. Usually, I'm usually trying to just tell the client it's really important that you're telling the investor that you're going to use their money wisely. You're going to make a good product. You're going to take $200,000 and make it look like a $2 million project. And you've got a well thought out strategy on how you're going to make that money back, along with a formula that will allow them to get that money back. Because generally, most investors I know that generally, if you can give them their money back, the odds are very likely they'll invest in you again. And so it's a tricky market, but that's usually the approach that I recommend in trying to get investors. That is a very crash course on the financing side. We've got about maybe 18 minutes left. I want to talk about distribution. The classic distribution were these windows. You first go to a distributor and you end up in the theaters, and then you end up on TV, and then you end up on airplanes and their foreign rights. Well, I think everyone here knows that technology has pretty much destroyed those windows. There are really two major factors. One, technology, especially in the streaming world, and how now on, I don't have my smartphone handy by me, but how on my smartphone, I'm watching just as much content as I would on any TV. And then beyond that, the cost of entry into getting into the distribution world, the cost of entry of making a project and then finding a platform is much easier these days than, it was, even 10, 20 years ago. But the question of how you monetize your film in order to make money back becomes even more clouded, because now you have a sea of product out there and you need to somehow try to find a way to brand it and get people to watch it. And, certainly the marketing and social media and the viral aspect of things can do things with that. But these days, even the major producers, the major distributors are trying to figure out ways to better market and get, people to pay attention. Of course, COVID did not help. All of the major film companies were out of the studios in in 2019 and 2020. I mean, we've only just seen recently some of the major, studios back in the theaters. That created a good opportunity for a lot of mid-level distributors like Gravitas, some Submarine, some others that actually, on very limited basis started putting films into, theaters because they didn't have to compete with the majors, because the majors were, for the most part, out of the market. The majors are coming back in now, and so those companies are going back to their bread and butter. Obviously, the big, when you are negotiating a classic distribution deal, the obvious things you're asking are, what's the distributor going to do for you? The last thing you want is a distributor who just adds you to their catalog, and you just sit in their catalog and nothing's happening. So when you're, just because you have someone that's a distributor that's interested in your project doesn't mean anything. Certainly doesn't mean anything to me if I'm your lawyer in it. There's a lot of due diligence that I'm going to ask. What are you going to do for the film? Are you going to budget any type of advertising? Can we get that commitment in writing? How will I make money? And what are those scenarios with that? Sometimes a distributor will take, most of the time, a distributor will take a flat fee right off the top, off the first penny. That can be anywhere on the low end of 20, 25% to a high end of 35, even 40%. But usually if it's on the high end, that's because there's an advance that's been given. That means that I already have an advance that's coming in of the project. So those are two sliding scale factors, and then expenses. And you usually want some cap or understanding of how expenses will work. I'll always negotiate a cap and say, you will not charge this film expenses beyond a certain dollar figure without our permission, because at least ask us once we get to that dollar figure what's been done and if anything is worthwhile. Sometimes a distributor will say to me, well, you're taking away our incentive to really market this if you're going to make me have to ask you every time. Well, why can't we just agree on a number that you think reasonably will provide some return or some success? And if you can't give me that number now that I can use as a cap, do you really know what you're doing? Or are we just arbitrarily, picking up a number here? So there are ways to talk around that when you're talking with a distributor. I mentioned earlier that I'll always ask a distributor to give me models, like what is a reasonable, guess on how this film, just all things, average, what's the best case, scenario, and where are you, taking that, and then, will you give me some sort of reversion if for some chance there's just nothing happening with the film. So those are some of the key things. Now with the streaming, like if you will go to now there are distributors out there that really specialize in going to streaming companies and trying to sell a project to a streaming company, and then if they're not successful, then they have their own streaming, which doesn't really mean a whole lot. So you have to be careful in really understanding how the distributor operates. Do they have a booth at Toronto and they just have a bunch of catalogs and they try to get people to come in the exhibition hall to come up to their booth and buy rights to certain projects? Are they acting like a producer's rep that will actually know possible distributors and will try to represent the film to potential distributors and set up exhibitions or screenings in order to get those rights sold? Or do they just have some kind of platform of their own that may or may not mean a whole lot of anything, that you have to kind of play detective to figure out that they're just putting it up on the platform and just seeing what happens, And if something sticks, then they have interest in it. But then otherwise, they have a catalog of content that not a whole lot's happening to it, but makes them look like they've got, a big, huge catalog. I would be remiss in not talking about Netflix, Amazon Plus. I've given you a bunch of information there. Interesting, in classic distribution deal, you always have some barometer in box office sales or other data that shows how your film is doing. One of the more interesting phenomenons in Netflix is that Netflix would, for a long time, would not provide any data on how the films they acquire and how they do. They usually it's a set film, and they were really affecting the structure of the marketplace. I remember I was talking with the president of Broadway Video about a year ago. I was at a place where he and I had a chance to have a conversation, and Broadway Video in New York has all the NBC late night stuff, Saturday Night Live, Fallon, whatever the late night programming is from NBC. And he was telling me, look, I've got all this content from NBC, and I can't get Netflix to tell me how it does. So that model of just kind of selling your film or licensing your film for a set dollar amount, and perhaps having some sort of bonus feature in there has pretty much been the model. And then you've had different streamers, Amazon Prime with a slightly different model, each trying to show that they're doing offering you potentially a better deal with that. What does that look like? You either have a film that's completed in the can, and then Netflix or someone might pick it up, or they might be willing to advance you some money to make a project. That's because you have the rights to it, and it's so valuable that they would hire you in a co-production scenario to do that. I say that to set the stage that Netflix now just announced like 2 or 3 days ago, that they're now going to start releasing data on like their top 10 performers. And I know the reason why they're doing that is they're yet again trying to change the marketplace and trying to affect their competitors in the streaming world to follow the same suit. So if this program was like 5 days ago, I would have gotten into some more detail about what you're going to expect. But I can just tell you, even as of just 2 days ago, Netflix now is slowly taking the baby steps to move into more traditional structured deal where you can actually potentially see data on how your project does on Netflix, and will be able to then negotiate off that, what types of royalties or things that you might see there. Very much in the infancy stage, very big surprise, because I don't know that a lot of people saw that as a potential, but I'm going to just say one more minute or two, because I want to keep us on time. And as I said, there's even more I would love to get into, but believe it or not, even 2 hours is just not enough. It just flies right through. On distribution, know who your distributor is, do due diligence, talk to other people that have used that distributor. Are they having crappy experiences? Are they getting paid on time? Are they getting accountings? Do they have what it is? Look at what their best films are. And if their best film hasn't done more than the total money that you're trying to raise for your project, you don't want to go to that distributor. So there's a lot of common sense things that I think you can do. And most honest distributors that are very, upfront, they'll answer these questions for you. The ones that won't will, you just have to have a red flag for. A Kirk Schroder weekend retreat. Yes, I get to pick the island and the resort, but I could talk about this stuff all day long. Let's see, last question. What might be a good range of funds a filmmaker should set aside for a lawyer and or legal services for projects? Well, here's a question about the lawyer. Usually what I try to do is just quote flat fees, except on distribution. I'll charge by the hour because it's just a phone call, looking at a contract, maybe another phone call, and boom, the agreement's out the door. But I didn't even get into the production phase on what if you have a union production and what the different phases are with respect to the unions. They have a low budget, short, experimental, and then the scale. Your fees are going to be a little higher if you have a union production because there are lots of rules and things to jump through. If you have a union versus a non-union, and I'm not just talking about actors, your crew, IA. If you have a writer, are you WGA? And you have to remember, I have a lot of clients that have a lot of experience in doing non-union Hallmark, type Christmas. I don't know how many Christmas Hallmark productions I've represented over the years, but then all of a sudden they get into a union thing and they're just totally in the wind about that. And then they try to cut corners without telling me, and they get in trouble with the union, and that becomes its own issue. But usually on the production end, there's usually like maybe 5 to 7 agreements that you need that are just set documents that we can usually tailor for you in the production phase. And you're probably looking anywhere from $2,500 to $4,000, depending on how awful the production is and how complicated it is. On the financing stage, I always will quote a flat fee with that, but usually I'll have the client promise that you're only going to this many investors, you're only going to this many states, and this is going to be the structure of it. Because then if the client starts shifting on that, then there's an understanding that we have to renegotiate. And distribution, I'll just usually charge by the hour. I'll just say, I want to just emphasize again on the investment side, there are a lot of people, lawyers, that will just sell you a cookie cutter form that will comply with everything, but there's no thought into the form on how to sell investors on it. And so you might pay thousands of dollars for something that looks really pretty. It's got your name and this and some bios and this, that, but it's not designed to protect you and sell the investment. And that's usually the added value that a lawyer, I think, needs to help be in mind. We got like maybe 3-4 minutes. Are there any questions? I promised Jonathan I would land this on time. And as I said, there's so much more I could talk about, and I'm sure I've skipped over some things. Any questions? I will pop my email in the, and you may have to give me you can send me an email, but you have to give me a few days to get back with you to sometimes with the way things are going. The last thing I'll just say, if there are no questions, this is still a great market to be in the content industry. Content is king right now. And so I want to be very encouraging to everybody that if you have a creative idea and you have the skill set to tell that story in this medium, I can't think of a better time to be in the content world, because there's always a place these days to find content. And if you're patient and you're smart and strategic about it, you should be able to, hopefully not only get creative content, any insight on any creatively, but also monetize your content. NFTs. Yeah, I did a program for the Arts Council on NFTs. I was just talking with an investor last night who was just telling me they're not investing in NFTs. Actually, a rather sophisticated investor. So I don't know if anyone in the sophisticated film arts area that's right now investing in NFTs because it's still very volatile. Digital can be altered. So there's still a lot of hesitancy in the market that I know. Jonathan, I see you popping on the screen, so that means my blah, 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 blah time is up. But
well, Kirk, thank you.
That
so
means
much
I can have my apple cider vinegar drink right now, right?
Absolutely. I want to do some housekeeping. I want to say thank you again to the Tennessee Entertainment Commission for sponsoring this webinar. I have shared in the chat all the code for any attorneys attending for continuing legal education credit, so make sure you have those materials. I've also shared a link for the resources that you shared with us, Kirk, and we will email those out along with a link to the video recording so people have access to all the materials that you provided. I know there's a wealth of knowledge in there as well. And then I've also shared, and I'm going to share this one more time, an evaluation survey. Please take a moment to give us feedback on the webinar. We'll also share that link in the email with the link to the video recording. So everything that you're supposed to have will come to you in an email. But Kirk, thank you so much. This was incredibly informative. I know it's a packed 2 hours, but I think you answered a lot of questions and covered a lot of ground.
Thank you, everyone. Thank you for your time and attending.
Yeah, thank you, Kirk. We appreciate it. And thank you, everyone, for attending. Follow the Arts and Business Council, abcnashville.org. Follow us on social media, sign up for our email newsletter. We're going to be doing some deep dives into film financing, music sync licensing, different things in the series. So you'll want to follow us to be able to keep up with that. Everyone have a great day and have a wonderful weekend ahead, and a happy Thanksgiving next week.